One. Next slide, please. And here now is our video conferencing platform. I think this is very interesting considering the challenges we've had people facing when it comes to video conferencing. Initially, when we started, we tried to use other tools such as Zoom, Microsoft Teams, and others. But the problem was that they were complicated. This is during the height of COVID era. We've not focused on it since it's already been highlighted by everybody who presented before us. But at that point, I remember the frustrations of trying to guide somebody who's not familiar with technology, how they work with Microsoft Teams, how they will need to install Zoom either as a mobile app or as an executable in a computer. So basically, as we were working on that, one of the things that we noted was that we could do better. We could provide a platform where a single link is available to visit. Somebody can visit that link, can hold a conference, a dispute resolution settlement conference, all through to the end. And without the timeouts, I saw that a few minutes ago where a Zoom conference was counting down. So in a sense, we have our own in-house solution that avoids all those particular challenges. Next slide, please. And now when it comes to the lessons now that we've learned and the observation, now that we are back to the legal component, my partner, Mr. Erastus Njaga, will cover that now that I've covered the technology behind it. Thank you.
Good afternoon, everyone. As opposed to an atypical academic paper, what we are seeing is the journey of Tattoo Center, an enterprise trying to promote accessible, affordable, and cost-effective justice. The reality is that, one, technology, most of the one we are talking post-COVID-19 pandemic, it has been a reactionary approach. As opposed to Tattoo Center, we invented the idea before COVID-19. So ours was not a reactionary approach to COVID-19. The other thing is about cultural relativism, where we are saying that no matter how much we talk about technology being unique or being an universal thing, it isn't, because there are demographic and geographic issues to consider, and also the personality of the issue. The other thing we can talk about is the element of interpersonal relationship. With regards to technology and the use of it, there seem to be lacking the interpersonal relationship and the psychology of things. The other we can talk is the barriers that has been talked by majority of the speakers, the electricity, the internet. But what we have considered major as Utadudi Center is there seems to be lack of a global recognition of African developed technology. A majority of players in the justice sector seems to have a preference of the westernized technology. So we have tried to approach certain institutions, including judiciary, to give them our platform, but we are often than not, we are told that they have recruited other technologies majorly from outside the country. So with that, we mark the presentation of the Twin Center. This is a journey of us as an institution, and thank you for listening to us.
I will attempt the impossible, which is discussing a paper and running a marathon in 15 minutes. So if you indulge me, let me just begin. And my paper really focused on the role of paralegals in enhancing access to justice. As has been discussed in previous sessions through various papers that have already been written, you'll find that in Kenya we have very flowery legislation. We have a constitution with a Bill of Rights, even a chapter on integrity, which is the only constitution in the world with a chapter on integrity. We have other legislations that really try to cater for the needs of the poor and the marginalized. But these promises of democracy, equality, and justice remain a dream for many. And these are billions in the world, and Kenya is not an exception. So that gives pretty much the justification to have a growing and vibrant paralegal movement in Kenya. And in crisis and situations such as the public health emergency that was COVID-19 affecting everyone, the marginalized, the rich, and each country in this world, we saw that these were key players in accelerating access to justice. I've tried to just summarize the key justice issues that were specifically touched and affected vulnerable people. But before I do that, let me just anchor my discussion in the law that guides paralegals, and that would be the Constitution of Kenya. I won't belabor all those articles, as we are told that we have to read the Constitution conjunctively when you're talking about socioeconomic rights. Think about the dignity of individuals, think about the national principles under Article 10, think about Article 47, fair administrative actions, which all touch on socioeconomic rights. So what are some of the advantages of having a paralegal movement? Paralegals, I'll just summarize that. Paralegals do the work of empowering the masses. Knowledge is information, and once you know what your rights are, you're empowered. And once a society is empowered, they have agency. And once they're involved, they even feel like they can take action to improve their situation. So that's one of the advantages of having a vibrant paralegal movement. Another thing you'll notice is that paralegals use mixed methods, okay? They're just not stuck to litigation like lawyers or just writing nice judgments. They can use advocacy, they can use mediation, organizing, monitoring, and such methods. So they're very creative and constructive about how they achieve various objectives. And then they're also creative about institutions. Okay, so if this doesn't work, they'll go to another institution. For example, if they approach courts, and let's not even go to courts, if they approach perhaps the Kenya Human Rights Commission, they might say, well, that's really out of our reach. We don't have a thematic area in our institution. We're an NGO. We only have funds to cater for this. They can go across the road and file the case with the Kenya National Commission on Human Rights, which has a broader target, and it might cover issues that they might have brought to the focus. And then they have scalabilities and cost effectiveness. If you take your issues, particularly in the community, who most of the time have their disputes resolved outside courts, you can have your issue resolved within minutes. You don't have to spend 1 million shillings. You take a brief to Shem, and the bill that will slap you is going to be running in the millions. Okay, so that's one advantage they have. So I've talked about the Constitution. We also have the the Legal Aid Act of 2016. The regulations, as you heard yesterday, are yet to be validated. It's taking a while for one reason or the other, but we hope that in the end we'll have a proper and well-regulated system. So this paper, you will notice, I just don't focus on the accredited paralegals as per the Legal Aid Act. I also look at the non-accredited paralegals, who we call the barefoot lawyers or the community paralegals. So there is that broader definition of paralegal under the Pasune handbook of the paralegal, what's Pasune info? Support network, yeah? So there's that broader definition of paralegals. So what are these clusters of justice issues that I've particularly focused on? One of that is socioeconomic rights, there's gender justice, there's property rights, there's police brutality, torture, and arrest, access to courts and corruption in the healthcare system. And I would not be too preemptive to say these are all the issues that were tackled by paralegals, but I feel that their work came out better if you look at how these justice issues were addressed by the paralegals. So when you discuss about the rights to health, as was touched by my senior Dr. Ogendi, is that health is quite a fundamental right, and if you don't protect it, then you do not have a healthy nation or a strong nation. And as such, the Constitution anchors that right under Article 43. And you'll realize that once the onset of the pandemic was very impactful in Kenya and in the world, but in Kenya in specific, where we have other health issues such as HIV, malaria, and the growing number of non-communicable diseases such as diabetes, kidney problems, there was a shift of focus and certain people were left out. So paralegals in communities, and due to the malleable work they do, if you used to focus on a specific thing, some are able to shift their focus on issues such as HIV, supporting women, mobilizing communities and supplying them with water and water tanks for regular hand washing to contain the spread of COVID. Others also partnered with larger organizations in the distribution of contraception to avoid unintended pregnancies and STIs. And then mental health care was also a growing issue. We find that some paralegals have been trained to give counseling support and psychosocial support to people who are really burdened and stressed out due to the pandemic. Also in GBV cases, they came in and supported people struggling with ill health due to GBV and the effects of it. When you talk about the right of education also anchored under the Constitution, you've seen that paralegal work is very elastic, and some are able to shift their focus and provide basic education for many children who we know obviously now had to stay at home, and they were able to partner with other organizations and provide educational libraries, because you could not have a group of children that would have been against the government restrictions. So when you talk about the right to food, some paralegals, particularly in the coastal areas where there were lots of layoffs due to the downturn in the tourism sector, there was a lot of layoffs, and this made some paralegal networks in Kisumu, in Kwale, in those sides of coast, to come together and just take measures to support people with food aid in the region. So that's one thing. We also have an example from Laikipia, which I've talked about in the paper, where closure of livestock markets and even in curfews exacerbated food and livelihood insecurities. So they were quite instrumental in just ensuring that at least this basic right is met in one way or the other. And the right to housing was also touched in the morning. And it's unfortunate that some of these things happened. When you talk about evictions during a pandemic, that's one of the worst things that could happen to anyone. But you find that some paralegals, I picked an example from Kisumu, they stepped in and just intervened to stop the forceful eviction of one of the tenants, who was told to just get out without any notice. If you don't have, again, I said legal empowerment, you're subject to a lot of mistreatments by people who have the power and the muscle to do that. So you can find other networks talking about paralegals being a last mile approach to governance, where you go to the grassroots and see how you can leverage on the social capital and use those networks to distribute. I've heard about direct transfers or certain types of aid that could be given through the existing networks that even the Deputy Commissioner talked about. The right to information was also a challenge, but paralegals were able to I'm sure I've heard of Kituo cha Sheria holding radio talks just to talk about police brutality and other emerging justice issues, such as illegal um, firing at work, because there was a lot of that. People took advantage of that. So information was very key, and the right to information was also showcased through the work of paralegals. I won't belabor this point of how COVID-19 and gender justice became quite a focus area. We talked about FSGBV and early forced marriage, since most girls, particularly in the marginalized areas where social norms promote issues such as early forced marriage, paralegals were able to intervene and take action through reporting, and they could do this through the intervention of chiefs and the coordination of even teachers to just help the victims get out of such situations. Um, and in the same breath, there was intimate partner violence, such an increase to the extent that the president commissioned the National Criminal Research Center to do a report which showed that a lot of women had become victims of intimate partner violence. Hence, the work of paralegals was also very important in just helping these people. I'm not sure how many safe houses are run by the government, but you'll find that some paralegals, through lobbying and through other organizations, were able to offer safe houses for victims of intimate partner violence. We can talk about property rights, but I'll just touch on this very broadly because it's quite, I haven't done too much research on this. I'm yet to grow this area, but you'll find that there are other declarations that, for example, the one that was made for the Ogiek to occupy, to restore their land rights in the forests, but the government had, at just that moment, through the judiciary in specific, they just, put their tools down and said, okay, let's just find our ways around this pandemic. We're not going to listen to anything else. So you'll find that there's a paralegal movement among the Ogiek who are still pursuing the land rights and property rights that had already been vested upon them by dint of the court order. And then we can talk about police brutality. They're very key in giving information about what was happening on the ground, particularly in posts. You saw the pictures in the morning. They were the first responders in issues of police brutality, because when the state is not on your side, then whom do you run to? When it came to access to court, there was also a problem, but a lot of legal aid centers were established. I think there was one in Nakuru, which is run by paralegals through the auspices of the UNODC. So you can find that they bridged the gap when it came to access to courts. I want to also talk about justice as relates to corruption. There is always a nexus between human rights and corruption, and the paralegals were not left behind in putting the government to account. They took a human rights-based approach in telling the government it's your duty to protect the frontline workers, it's your duty to provide healthcare services for free, particularly in health pandemics. There were several press statements that were done by paralegal networks or paralegals who acted in their own capacity. So that's also elaborated briefly in the paper. So there were certain issues that face paralegals, which are pandemic specific. I attempted to just interview a few of them, and I saw some of them and I condensed them into this slide. So the in-person nature of paralegalism was surely interrupted because of restrictions, health restrictions. You could not meet face-to-face. You could not have legal aid clinics where you assemble people and you talk about issues. So that really impacted their work. And then there was also the issue of how to respond. Paralegals were not considered essential service. So in cases of emergency, if there is an SGB case or an IPV case, a paralegal could not access the victim as was needed. There was also a digital divide where some paralegals really did not have access to the information, no, the digital technology to enable them access maybe information they needed or to report a case as fast as was needed. There's also need for paralegals to move to certain areas where people could not, maybe victims could not move beyond due to the movements in restrictions, and then due to the curfew. So where paralegals needed to move to certain areas to intervene, the chances were that they did not have any money to do that. Of course, since this was just, never planned for. It was a pandemic, very sudden, and that was not really in their budget or, such reasons. And emerging justice issues as a result of the pandemic, such as police brutality, were sometimes beyond the capacity of paralegals to ensure adequate response. I've talked about the issue of safe houses. If you have a safe house that could cater for perhaps 10 people, and now you have a surge in the people who need to be admitted, that becomes a challenge automatically. And there was also a lack of coordination amongst justice actors. So you find that other CSOs are planning something else. The judiciary is making its own plans. Maybe the Ministry of Interior is making its own plans. So there wasn't really a coordinated um, approach. So what interventions did paralegals make during the crisis? So some paralegals set up online links to assist with legal aid and GBV issues arising due to the pandemic. They also have talked about the radio awareness campaigns around increasing human rights violations. There's also online mental health support because that became a forgotten area, as I've said. Toll-free lines, social media, and bulk SMS outreach. I remember receiving some texts from other CSOs and paralegals saying if I had any issue, I could report to that. Then there's also an uptake of documentation. I've talked about what happened, particularly in Coast. Muhuri really used the paralegals in that area to just collect information and data. And this even made the president make a declaration that police needed to stop the excesses because it was becoming too much. And then there was better monitoring of SGBV cases in collaboration with gender desks in police stations. Although the police also, there was a challenge that, instead of them responding to issues arising such as SGBV, they were out there enforcing the curfew, beating people up, sometimes shooting them, killing them, which is quite sad. And then there was also civic education on COVID-19, which was done by paralegals. So what was the paralegal advantage during COVID? It goes to the things that we talked about at the beginning, that they could leverage on considerable networks to disseminate and amplify vital public information and messaging about COVID. They could also be used by other non-justice actors, okay, to help marginalized groups to access aid, such as, I think, Red Cross, all those people. They also played a role in improving the accountability and effectiveness of COVID-19 response and recovering programs, since they could help people secure basic services such as food and financial support. They could also be used as key persons to help monitor and report human rights abuses and other injustices that arose under quarantine, lockdown, and stay-at-home situations. And they're also critical in building stronger preparedness systems after the pandemic because of the one-on-one experience, the ground experience they had. They become quite crucial in just trying to see how we can scale up this discussion around access to justice among justice actors. So how can this work be scaled up? I've tried to see, and I've tried to just condense and discuss about this. I can see Brian standing up. 5 minutes. Thank you. So the first thing that needs to be done is to empower and encourage these paralegals, whether they're accredited or unaccredited. But that's a discussion that can also be picked up because of the concerns around the need to regulate legal aid service. You need it to be quality, you need it to be fair, and all those other categories. Then there's also strong collaboration with advocacy groups to secure human rights, and as such as adequate housing for the homeless when a lockdown was in effect. There's also the possibility for regional collaboration among paralegals, where we can discuss, see what's working here, see what didn't work here. And there's also a need to scale up remote and rapid legal advice. Yeah, because we've seen that the digital divide leaves very many unattended to and underserved. So I tried to see some policy, just to give some policy recommendations, and I'll just summarize them. These are not really complete, but one of them could be that governments and donors should consider nurturing grassroots legal empowerment efforts. This would begin by first acknowledging that paralegals are quite an essential service, especially in crises such as public health emergencies. And another thing would be to develop mechanisms or utilize intermediaries to efficiently get core funding to large numbers of grassroots justice actors, instead of the money passing through very many, the bureaucracy in Kenya. Sometimes the people who are nearest to the problem know the exact solution that is going to work for people. And then you can have integration of paralegal empowerment efforts into national COVID-19 strategies and stimulus packages. Still speaks to the other policy recommendations. And then finally, we need to recommit to the ideals of SDG 16 that focuses on peace, justice, and strong institutions. But beyond that, I think paralegals and their work is really driving towards the deeper versions of democracy, where we have an empowered people, people who are actively involved in the day-to-day lives of people. And they take, instead of just going to the ballot and casting your votes and you're told, okay, now this is democracy, that you're actually involved in the institutions and in the rules that affect you daily. Thank you very much.
We'll now move to the question and answer section.
I was very keen on Dr. Aura's presentation, but which was really good. I just have one question. I'm not sure whether it's safe even going forward, because I'm also a gender activist. Is it safe to say that we people are bifurcated into two, men and women, when we have the intersex people? Now they're recognized in our country. It would be just that.
Thank you very much. Once I want to commend the presenters for this afternoon for well research paper. So my question goes to Ruth or Carla, and maybe probably to all of us. I've been struggling to get to know the definition of paralegal. I was able to follow through one of the slides that you have attempted to give a definition of paralegal. I'm sure even yesterday we had the CEO, the acting CEO, also talking about it. And in the presentation, you mentioned about the regulations of, I think, operationalization of these paralegals. So what I have in my mind as a question, and to all of us, is in the registration, have we managed to get to know maybe the qualifications of these paralegals to be? This is for all of us, and maybe Dr. Oganda, and Oganda can also assist us in that. Thank you.
I also have one question and a comment to make. The comment goes to the second presenter, my former student. I like the way you made your presentation and talked about the advantages of online learning. But as a teacher, I want to express my disappointment with online learning, but that does not mean I'm discrediting this method of teaching. One, it becomes very difficult to control the students or the learners online. We have participated, like now those who have families, somebody's at home, mtoto anasema, mami nataka nyonyo, those kind of things. It becomes a little bit to manage. Secondly, some of the students who appear online, they do not want to give their proper details, just like your name, so that I can recognize and identify this is my student so and so. You know the funny names that I used. Three, now, this is even very, very worrying. I give a link, the students sign in, they are admitted, right? But then they leave their gadgets on and disappear. So when I ask a question, when I ask a comment, I even reach a point I say, Mr. Mwiruri, can you answer that question? Mr. Mwiruri is not there, but it is the gadget which is there. I think this sometimes also can compromise the quality of learning. And very finally, my students, I know you are a young man, but we have other students here who are elderly. You have 3 live assignments. One, you're in Nairobi working from 8 to 5. You know what time you wake up to get to duty and what time you are going to get home. 2, you are in Kenya School of Law. 3, you are a family member. There is another life waiting for you at home. Is it possible to balance on that? In as much as you can talk about online, that it will be recorded, you will be able to go through. Yes, you as a young man who is single, you can manage that. But it would need to work for some of us who are adults. I think it is something that we need to understand, that in as much as it has brought advantages, right, it has also some disadvantages. I taught a class, the gadgets were on, but I found one of the students was in a matatu. And you can imagine the noise. Yes, it is online, it's there, but is he following? Can he answer a question? Right, those are my reservations. But I would rather face to face, the demeanor comes in, unlike when you are online. I didn't want to answer a question, but I have a question for the 4th presenter on Paralegals. One of our colleagues has raised a question about the qualification. This has been a challenge to set the qualification, but some knowledge in law will be required. How far a person should be learned is not very easy, because law is wider in scope. Just as lawyers, we specialize in some particular areas other than the general courses that we do. It's not possible for the paralegals to have a wider scope. But my concern is this. Our friend from Makueni, you are a paralegal. Maybe you can assist us to respond to this. These people are going to be accredited. Do they qualify to be professionals? And if that will be the case, if they give wrong advice on anyone who comes to contact with them for purposes of accessing justice, can somebody sustain an action against them on professional ethics, right, or professional responsibility, or cases of negligence? This will go to the 4th presenter. What will be your reaction? Thank you.
Good afternoon. I will restrict my comments to the Dean, Dr. Ora, and her presentation on gender. To understand gender, for those of us who are men or who don't get this gender message, There's a book that when I deal with jurisprudence, I always urge my brothers and sisters to read. One by Paulo Freire, Pedagogy of the Oppressed. You can only understand the problems of somebody who is oppressed when you get it from their perspective and get it from their mind. So those of us who don't understand the gender component, the gender argument, Pedagogy of the Oppressed, Paulo Freire. Nonetheless, those of us who are imbibing the feminist gender knowledge and jurisprudence, we have to absorb that branch of knowledge with the hindsight that we are operating in a certain context, and Dr. Aura alluded to it, that that message faces hostility. So how do you express it? And those of us who are trying to move to the new age jurisprudence are arguing this, that let's have jurisprudence tailored for the African context. So for example, there's a lady called Marimba Ani, that's her nom de plume, her pen name. Original name is Donna Richards. She has a book called Yurugu, and that is a very good book for those of us who want to understand the African criticism of knowledge and pedagogy as we will want to appreciate it. And she talks of three things as I finalize. This is what she called asili, the central seed. How do we deal with the matrix in our cultures? Then there's what she called utamawazo. How do we culturally structure our thought and worldview? How do I look at the world as an African? Then she has what we call utamaroho, what the Germans will call vokjis, the spirit. What is it that animates you as the moge koyo, the kisi? So when we structure our jurisprudence around this knowledge, we will perhaps find something that will resonate with the gender message within the African context. So let's depart from what has been trained to us as lawyers and find what will resonate with us in the African context. Thank you.
Thank you. My comment, I want to be sure it's allowed. My comment is a rejoinder to a comment made by a colleague. So is that allowed? Can I comment on a colleague's concern? Okay. So I've listened to what my senior here said about his thoughts on students' inability to follow through classes, which is true. It's very true that online system is very hard to monitor. However, my observation is that I think I find that to be more of a problem of lecturer than student, because I think in mediation there's something we normally call power play. It means mediation is becoming common and acceptable because the person who wields power is brought to a certain level playing field. So my observation is that while as a lecturer you'll be losing that power to control a student in a physical class, I think probably we need to get used to it that our jurisdiction is wrongly designed, that a student, when it comes to class, he must swear some form of allegiance and tremble and show some form of respect and recognition to me as a lecturer, so that my business remains teaching. If this student chooses, as they sometimes do, not to attend the class and is an adult of sound mind, then I feel I should be given the leeway to let the student be, rather than bother too much about whether he is concentrating in the class. However, I know how difficult that is. It's just a thought that probably we should mind our business and teach, and then whoever wants to listen, let them listen. After all, as a lecturer, I have other avenues of bringing order to class. I control the exams, I control the cards. I think I can punish the student elsewhere. That's just my view. Thank you.
A comment. A comment. Uh, there were two questions that were asked on paralegal work. One from my colleague there, and the other one of Getanda. As a paralegal working in the rural areas, I think the process of accreditation is still in the pipeline. But I think my colleague Ruth Okara, please, I think you're going to elaborate on this issue of accreditation of the paralegal work. Thank you.
And I have a question to one Mr. Mururi from from Utatuzi Center. So actually, I would like to comment. It was such a nice presentation, but I have some concerns. Your use of technology majorly is centered on the ability to access the internet and the use of gadgets. How are we going to access those people in rural areas? As we know, in rural areas, not everyone has access to such, and they have a lot of legal issues that exist. The other thing is on the issue of representation and follow up. You know, when you offer legal aid, maybe there's some cases depending on the degree of seriousness that will need representation in court. How are you going to do to deal with that issue? Then on follow up, when you give someone legal advice via the online platform, via the virtual platform, how are you going to follow up and realize that the advice that you gave was effective? And the other thing is the jurisdiction of coverage, because online users, there are many, so they come from different places in the country. So is there like a partnership with specific organizations in specific areas? How do you deal with issues, because there are some issues that maybe they will need some referral or something? Yeah, that's my question.
Hello, good afternoon. I'll comment on a light note and then I'll ask a question on paralegals. The issue of online teaching has been, it's not easy really, but I hope as we go ahead it will be better, because some of us are also having quite challenges, as some have said, especially when students like a student science with a name Poison, and it's online. The name is Poison, and will you even want to have someone Poison in class? And on the issue of paralegals, I have one issue about accreditation. What is the consequence of accreditation? Is it not going to limit other people who could have provided legal aid? Because, all right, fine, that's one question. Another question is, do you think lawyers will accept to have paralegals accredited? Because it is taking their work. Enough said. Thank you.
Before Ruth clarifies on all the issues that are coming up, I'd like to give my opinion on the same, because we work with paralegals, and I think Ruth mentioned in her presentation that we have those paralegals who have undergone paralegal studies, but then in the country, and in a country where the government has not been performing its role as the primary provider of legal aid. Under our constitution, we know yeah, under Article 48, we have a right to access to justice, which includes being able to have legal aid. So the government has not been doing that for a very long time. And that is how these other community paralegals came up from a long time ago. Since I can say from the times when, for example, Kituo was formed in 1973. At that time, that's when paralegals came up because there was a need for legal aid to the people. The lawyers were not enough at that time, and they needed community people who were known by the community, people who are respected by community members, who could actually be taught on principles and aspects of the law and assist members of the community. So that is where the problem is emanating, because the government has realized, oh, this is our responsibility. So now let's make a law. So now they've done that, and they say they are going to choose who is in and who is out. But these are people who have actually been doing this work. And on the question of who supervises them, I believe for the community paralegals, they're usually supervised by the organizations they're affiliated to, or the organizations that trained them initially. So those mechanisms have been there even before the act came into force. But now, also, I feel it's, but she will respond if she has the right answers. Yesterday was the perfect day to bring up these questions when we had a representative from NLAS, so that they can be able, and someone asked them this question, but you see, they don't answer, they don't give really concrete answers. We are waiting for them to actually tell us what next, because we are waiting to see what they're actually going to do. So I will let Ruth answer, but I feel like she's not the perfect person to respond to this concern on accreditation, because we know NLAS has that role, but since the act came into force, have we seen them actually do something or tell us who is in and who is out? And these people who are out, you found them there already working. So how can you say that they're out? So I feel like that is their position. Yes. Oh, I'm so sorry.
Okay, thank you for those questions. Yes, she has said that I'm not the perfect person to answer, and she couldn't be, more right regarding that. But the point that we're trying to make is this, that in a state such as Kenya, where you have such a huge gap in the capacity of the state to deliver on its promise through the laws that exist and what is actually available, you need the paralegals to come in focus and to take up certain responsibilities. And this has worked in Kenya pretty well. And from my experience, because I'm so much in the human rights space, you cannot get rid of the work they do. And I'm not too worried when you suggest that perhaps someone might get wrong advice. One of the advantages that I mentioned is that paralegals are very well networked. They consult widely. They can have, they go to any office that they feel they can get the justice that they need. So I will just throw this question to the duty bearer in the room to just address the questions of accreditation, because that was really the focus of my paper.
I can briefly react to the issue of accreditation and what NLAS has done. I know some of us may not be familiar with NLAS, despite the fact that we had a representative yesterday. They have had several progressive workshops, right, on how to implement the Act. The Act is yet to be fully implemented, and one of the problems they are having is the number of staff and the funding is not adequate. Now, the issue of accreditation, one of us has queried the question, what is this accreditation and what does it serve? Just like any other profession. how do you know who is in a particular field? Through accreditation. How do you separate professionals from masqueraders? Through accreditation. How do you hold practitioners responsible for their actions or omissions? It is the people who are accredited that you can deal with. How does the government get revenue? Through accreditation. Because when you are accredited, you have to pay some fee. And one of the queries that has arisen about accrediting paralegals, those of us who are already lawyers, you are an arbitrator, you are a mediator, you are registered in all these, accredited in all these other professional groups. And here you are supposed to be accredited. The issue of how much is to be paid. And remember, this accreditation fee all is going to the exchequer. And you are one person pursuing several professions. So the question also arises, how much that arises. But in simple terms, accreditation is a way of separating the wheat from. Thank you.
Thank you. And taking that discussion a bit further from where my senior just left it, the perspective of the regulator, which is the Council of Legal Education on this issue, is its mandate as derives under the Act, the Legal Aid Act, is restricted to regulation of paralegal education and training programs. That's currently the mindset of the Council of Legal Education. And actually that's the focus that we are in right now. We're in the process of actually developing regulations for accreditation of paralegal education providers. And in fact, as we speak, we have a very innovative curriculum that we are considering from the Legal Resources Foundation, the Paralegal Support Networks curriculum, which is the overarching umbrella curriculum that they use for the training of their paralegals. And to that extent, from a legal education point of view, accreditation of legal education providers is one way the Council of Legal Education will be contributing towards the accreditation framework for paralegals in the country. Moving forward, of course, we'll be partnering with the National Legal Aid Service. By the way, we'll be engaging stakeholders on those regulations as soon as 2022 rolls in, inshallah. So thank you.
All right. Thank you very much for
I have the microphone. I pick the mic. Then I'll give to Kyoko, who is my school, former schoolmate. Yeah. So you remember when you talk, when you don't have the microphone, you are losing the participants online. Yeah. So this young man, it's like there is a lot. What percentage of disputes are solved by the lawyers? Let us start from there and have an honest discussion. How many, like for example, where I am, the chief, as we are speaking here in the morning, when we call chiefs for meetings, before he comes to the office, the people who slept, a wife being beaten, a neighbor's cow coming over, these are cases that sometimes some of them are criminal in nature, but they end up in several other places for the disputes to be solved. What you receive, the lawyers, advocates who are here, they are what percentage? Actually, it's a very small percentage. And let us be open to that. That's why we need these paralegals. I welcome the idea of national legal aid. They should have come up with that curriculum, actually, so they can also control. We have pastors who are solving matrimonial disputes in churches. Is it? Even you at home, maybe sometimes you are called. Can you come and settle this dispute? So these disputes are many. You can't even do at 20%. So don't get worried. We are not occupying your space. You have a very big space. In fact, it will be very easy for you, such that you will deal with cases because you studied law for all those years. Deal with those technical cases. Leave the cases, the students here. These are the small cases like a neighbor and a neighbor dispute. Does it really have to come and bother you in a court of law? Thank you. Kioko, you can take over.
I have instructions. I'm holding brief for someone. Now, paralegals is envisaged in the Legal Education Act. And also, you realize in the policy, the national policy for legal aid, the accreditation process was also conceived there, and it is the Council of Legal Education, because it is mandated to develop the standards. They are required, to work with stakeholders to come up with the standards that is required to ensure that the paralegal, as a key sector, in the justice system, maintain standards, proper standards, even though we are saying they're not lawyers, yes, but they have a critical role that they are playing, and therefore they need to be regulated. And as he has already told you, a research has been undertaken and supported to ensure that the process of developing that standard is first anchored in the program. And they've already developed a curriculum that he has already explained to you, involving Legal Resource Foundation that has been he's not in charge of this a body for Pasune, but Legal Resource Foundation has been in the process for a very long time. So it has been spearheading and taking a greater focus in terms of the research, the curriculum, and even the accreditation process. All the lawyers, and even me, I'm a lawyer, I know I've been participating in that process. So lawyers are not resisting. I'm a lawyer, he's also a lawyer. And we remember that because the Legal Education Act requires any legal education that is offered in Kenya to be accredited by them, so they have to set standards that is very uniform and get the institutions that are providing paralegal services, to have that image of a serious profession, just like any other. Moses, if there's something I've left, you can add.
Yeah, that's it. Because because I just wanted to give a response to you from the perspective of AJS, which is exactly the discussion we are pushing at the moment. But let me finish with the analogy of the jungle. A lion will never be scared that they will go hungry in the jungle because the population of wolves is increasing. So everybody has their lane. Okay.
All right. Thank you very much, Dr. Aura, you have weighed in with considerable wisdom and insight. There was yes. So thank you very much. It has been an engaging session. We have had contributions focusing on a wide range of areas relating to access to justice. And the contributors, we thank you for your diligent work. The participants, we also thank you for your participation. You have made the session something that enriches our knowledge.